Good afternoon, everybody. Aaron Keller here on the Law and Crime Network, and we're in the midst of an afternoon break in the Tex McIver case out of Atlanta, Georgia. This is a case, again, that's picked up today for the first time in a little bit more than a week. The jurors had last week off. There was a week-long gap in the middle of this lengthy prosecution of a former Atlanta attorney who is now sitting in the defendant's chair on charges that he intentionally killed his CEO wife, Diane McIver. Of course, the defense, as you remember from covering this case up before the break, says that this was an accidental discharge of a weapon, that there was nothing nefarious going on. We just listened to some lengthy testimony from a PR associate who is a friend of the defense, who talked about some of the changing narratives early on in this case. And he was trying to break that all down. Where did the changing narrative come from? That's one question some jurors might have in their minds. It's interesting, ultimately, that this was a prosecution witness. The state still has the case. So we're going to break this all down with a person who's appropriate to help us break this down. Kenney Baden is here in the studio, here on Law and Crime, a person who needs no introduction.
Thanks,
but
Aaron.
welcome.
Welcome. Happy to be here. My first time. I'm so excited. I'm so happy for this network. It's fabulous.
Yes, we get to watch people like you in practice. We watched you in the Aaron Hernandez case, although the studio was backwards then.
Okay.
So we watch you, and in the midst of that case, we saw you watching us in one of the little laptops.
Yes,
there.
that's right. Yeah.
So it was like a two-way mirror. Yeah. So what do you make of this Tex McIver case? You've got a guy, he's facing 7 charges. You've got murder, you've got felony murder, you've got aggravated assault with a deadly weapon. The state seems to be lumping a lot of charges at this guy and hoping that somewhere in this slow lob of evidence that has just taken weeks and weeks and weeks and weeks to get out, they're hoping someone in the jury latches onto it and says, guilty. But does it add up?
Well, I'll tell you what, the state has a big burden here. They still have to show that this was committed intentionally if they want to get to this murder charge, and that gun didn't go off unintentionally. I mean, it's a really big thing. I was really interested. We were talking at the break about the gun and the issues with the gun, and that's where this comes down to. I mean, you've got the trigger pull, which could happen if the trigger's cocked. You have the trigger pull that could happen if it's not cocked. Could somebody handling a gun accidentally make it go off? Or is there really a nefarious motive here about finances? And I think that you may have hit the nail on the head. I'd want you as my defense attorney, because I'm going to...
I don't know. If I had my choice, I'd pick you.
There's going to be some things that are going to come in on the defense that these were tax ploys in terms of borrowing and financing of monies.
Yeah, I mean, the allegation is that this couple had sort of a bizarre financial relationship. But look, when you've got 2 very successful people who marry later in life, there's this loan back and forth, and the state is trying to paint this that the defendant was in just horrible financial straits and this, that, and the other thing. But I'm wondering, you know, look, is some of this loaning back and forth and the separate finances between the two, Diane there on the left, Tex on the right, is some of that done for tax purposes to somehow limit her, exposure to the tax authorities, and he's losing money at the law firm? Look, the guy is 72 years old. It's not uncommon for someone at that age to transition out of a partnership position in a law firm. Now, I know that. You know that. Members of the jury probably aren't attorneys.
But they're going to know that. I'm going to make you a 25-cent wager, because I play poker as my avocation.
I don't know if I'd win against
I don't know about that. But they're going to hear something about that, because you don't, there's better ways to commit homicide than doing it in front of your wife's best friend, where a witness to what had happened. Here's the gun went off. Did the gun go off in the paper bag? Was in the process of taking out, or the plastic bag when the gun went off? I mean, the trigger pulls are a very interesting thing, because I was involved in the Jason Williams trial when preparing the forensics for that. That was a homicide case some years back. And the gun that was the murder weapon actually went off in the courtroom. It went off accidentally. I was texting my BlackBerry, like, stop, make a note of it. And the defense team went, my God, Your Honor, this gun just accidentally discharged. So it can happen. And I think the ballistics person or firearms person also admitted that can happen. So I don't know if this witness advances that issue anymore. I don't see it.
This witness seems to be getting into whether or not the story was changing early on and who was driving the wheel when it was changing. And you raise a good point. I've been involved in high-profile cases. You've litigated high-profile cases. This guy is a public relations person. He's friends with the defendant. He steps in trying to help, but ultimately that may have done more harm than good.
Right. I mean, this is a good example why you never have public relations people dealing directly with somebody who could be accused of a crime. It has to be the lawyer. Now, the lawyer can then go to the public relations person, but you have to have that intermediary. This is pretty bad lawyering for people that were lawyers. McIver's a lawyer. This guy's a lawyer. I mean, it was just terrible because you can't really stem the tide of what the media is going to report. That happens later on in the courtroom if you do your job as a good defense attorney. But this was a disaster for that purpose. Now, ultimately, will it hurt McIver? It still doesn't advance. Did he intend to kill his wife?
To get to that intent argument, it seems to me that the state is going to have to get jurors to believe that this guy was just waiting for an opportunity to fire a gun and make it sound like an accident.
Right.
Because this whole scene, the traffic backup, the getting off the highway, the winding up in a neighborhood that, at least in this defendant's mind, is of questionable safety, the asking of the gun, the getting the victim to hand the gun back to the defendant.
Right.
That whole scenario, you know, if there's intent behind this pull of the weapon, then, and it's a financial motive, and some of the financial back and forth between the victim and the defendant go back years and years and years, that they're trying to pull into this case. The discussions of changing the will happened years before this bullet came out of the chamber of the gun. Is the prosecution going to be able to sell to the jury that this guy had been cooking this up for years and finally just took an opportunity when it came to him?
Sell it to the jury beyond a reasonable doubt, which, as we know, is the standard. That's really tough. Now, they've tried some things here with the charging document. They're trying to say that this was an aggravated assault, and an aggravated assault can be a reckless homicide. In other words, somebody gets killed because somebody handles a gun recklessly, and then by that infer that there is a murder called a felony murder. But that's not what they're trying. They're trying an intentional murder. They're not really trying a felony murder because they're trying to say there was motive. So what the prosecution is doing, arguing what they charge, are at odds with each other. It seems to me that there's a lot of stuff being pushed out there, and hopefully that one of the jurors may buy it and move the other jurors to convict.
I'm still sitting here waiting for something that's going to convince me one way or the next. Right now, it just seems like a lot of wheel spinning, but want to continue with our review of the testimony while we're in the midst of the break. There was a big issue right before this trial broke for the week-long recess that just ended with today's testimony, and that was a statement that Tex McIver made when the doctors came around the corner to tell him that his wife had died. It was a comment that could be interpreted as a racial slam against one of the doctors. The judge ruled on the Friday before the break that this statement would make it in front of the jury. It comes in, so the judge held that it was relevant. Let's listen to some discussion on that.
We were told that Mr. McIver was downstairs and would...
For this particular statement, I'm not offering it for the truth. It's just kind of the next step of how it is that he makes it to the next step of his process. But I can shortcut it and get it directly there.
I object to it being here tonight. If it's not being offered for the truth, it doesn't need to be asked at all.
Okay. I don't know that that's always correct, but here I think we can get to where we're going without that piece of information. So I'll sustain.
Dr. Sellers, did in your time from immediately reaching out, trying to contact the family member so that you can deliver this news, and your time where you actually come into contact with that family member, was there a delay of some kind?
There was a little, but because one of the things that's relevant is almost always, even at that time of night, the family is waiting in the surgery waiting area. And there was no one in the surgery waiting area.
Eventually, did you come into contact with Mr. McIver?
Yes.
And was he alone?
No.
At the time that he came up to have a conversation with you and Dr. Saeed, did you know who the other person was with him?
Yes. His, again, comments were he wanted to wait for his attorney to get there before he came up and spoke with us.
And when he gets up...
That's hearsay, Your Honor. He's relating what someone else told him because...
Right, I couldn't tell exactly how it was going to play out, but it sounds like our comments were, so you all should disregard, ladies and gentlemen, what Dr. Sellers just said. And I'm going to have you structure this a little bit more, just so you're able to get to where you're trying to go without us bumping into this.
Sure.
Okay.
Did you, at the time that you came into contact with Mr. McIver eventually, did you have an understanding of who the other person was with him?
I did.
And when Mr. McIver did come upstairs with the other, who all came upstairs?
Mr. McIver and the security person that was escorting him and the other person up.
Okay. Where did you go next?
Into the consult room outside or adjacent to the surgery wing area.
I'm going to show you State's Exhibit 507. What's in 507?
That is the sign outside the door, or next to the door leading into the consult room where we deliver the news.
All right, and just so the jury can be oriented to the layout there, where is this room or the door there on 507 in relation to sort of what you see when you get off the elevators there?
It would be immediately behind the elevators. The view from the front of the elevators before, if you were to go straight through the back of the elevator, would be that room.
And once you get off the elevators here and we're looking at what we see in 501, is there a waiting area up there as well?
From this view, the waiting area would be to your right and the back. The elevators are immediately right here to the left, and the consult room would be to the left of that.
Okay. So there's another, once you exit these elevators, another set of chairs, general waiting area, in addition to this room in 507. Is that correct? What about State's Exhibit 508?
That is the inside of the room.
It's 508. Once you came into this room, tell the jury what happens next.
Well, Dr. Syed and I were already in the room, and I was standing immediately next to the door, which would be right here. Dr. Syed was standing over here by this chair, and Mr. McIver and his companion came into the room with the security agent, or with the security guard, and the chaplain, I think, was with them, or that she was already in the room. I don't recall that specifically. But Dr. Syed took the lead and said, please, Mr. McIver, have a seat. And he was pointing to this chair here. And Mr. McIver, basically before the sentence was able to be finished, he said, "Don't tell me what to do, boy," which was not in a threatening way, but in an aggressive way, I would say.
And after hearing this comment, did you sort of take over, or what do you all do in response to that?
Well, it caught us, I guess, off guard a little bit. But, I guess at that time, when someone's, delivering this news, and not knowing what they already know, there's maybe a little bit of latitude.
Welcome back, everybody. That was some previous testimony in the Tex McIver case out of Atlanta, Georgia. The court is in a break in that case. As soon as we're back to live testimony, we'll bring you back there live. In the meantime, Kenney Baden remains in the studio here. Want to talk about another case that actually was the first case that we started covering here on Law and Crime.
Wow, I didn't know that.
Yes, we
Yeah.
launched the network with the Aaron Hernandez murder case, the second murder case. You were sitting at the table. Mm-hmm. Aaron Hernandez is sitting next to you.
Right.
Jose Baez is sitting next to you. It is a position in a chair that most trial watchers would just envy to be in, just to soak it up. So what's it like being in a courtroom in a situation like that, just as a threshold?
Well, you know that I've tried a lot of high-profile cases,
Phil Spector
case and all that, So for me, it's second nature. I mean, I'm more comfortable in that well of a courtroom than I am any other place in the world. I mean, just put me in that well. And the well of the courtroom, for people who don't know, is where the judge sits up here, and then there's a bar between the audience or the watchers, and then all the trial attorneys are here and the jury. So that's called the well. And so that's where I love to be, actually. You tend to forget everything else around you but doing your job as a lawyer.
So the verdict comes in. Mm-hmm. It's almost not guilty across the board. The only person that the jurors believed basically was the fiancée, I believe it was, Shayana. They believed that there was a weapon in the premises. So that came back with guilty. But this was a pretty clean sweep for the
Right.
defense.
Yes, it was.
And we made the comment here that Jose Baez, and I believe by extension you as well, were the masters of reasonable doubt. In a case like this, you've got so many colorful witnesses with conflicting stories of their own, and this all adds up to a masterful closing argument on behalf of Jose Baez, playing video clips back of what the witnesses said and trying to make it into a bunch of nonsense.
It was a bunch of nonsense
Okay.
in our view. As a matter of fact, we felt very comfortable from early on that we had an innocent client there. I mean, and think about this. This man had already been convicted of a homicide, and this was a double homicide that all these jurors knew about. So you had to have a pretty clear case of he didn't do it to get a not guilty, and our feeling was. So we were really confident with regard to that. And also, the witnesses here, what you guys didn't see, there was, as you know, Alexander Bradley was the main witness against Aaron Hernandez. But you didn't see the clip of the nightclub, and I'm surprised none of you went to look for it or asked the judge for it, because he had it in his chambers, where Alexander Bradley shot up another nightclub in Connecticut called the Vivo nightclub.
We talked about it a lot. I don't know if we saw it. Yeah.
And to see it was unbelievable, because he goes back to his car, he gets a .38, he comes back to that nightclub, and he starts shooting from the outside because they locked the door not to let him in. And it's amazing that people weren't hurt or killed in that. And when you see that it's a .38 Smith & Wesson, that Bradley was a gun dealer, he had access to these guns, and he shot up that nightclub, it put a real, for us, it was the moving moment that said, yes, we are clear that this is a not guilty.
Remembering back to that case, there were a lot of things that just didn't line up to me. Didn't one of the witnesses say that the gun that was in the trunk of one of the vehicles got thrown out on the side of the highway?
Right.
So then how does it wind up in another location?
In Connecticut.
And, you know,
right.
yeah, I mean, the gun is all over the place. You get the bullets aren't exactly the kind of bullets that belong in the purported murder weapon, and there were a lot of leaps made here.
And you had the issue of the forensics that I handled all the way through. I mean, we all had a third of the witnesses. Ron Sullivan, who was a great advocate, one of the best advocates I've ever seen for the law in a courtroom, had a third. Jose had a third, and I had a third. I had all the forensic witnesses. And there's a real issue about the science of this whole idea of bullets that can match up to a gun. I mean, it's a judgment call, and the president's commission, the previous president, had said there's no science behind it. There has to be, it may be valid, but it's not. And we try to show in this case the striations, the lines. In this case, we just took one picture, one of their pictures, not one of ours, that showed that there was a lot of issues that the bullet didn't match. It did not match. And of course, when their main witness is saying the gun had been thrown in a river, and then they're trying to say this gun was found as a result of an accidental auto accident, that all of a sudden they find a gun in the trunk and it happens to go back to that homicide. And then there was issues with the gun. I mean, they have a murder up in the state police, and they go fire it without using gloves, and they take DNA afterwards. There were a lot of issues in that case.
Want to give you an update. Sorry to pause
That's okay.
this, but the witness who was on the stand in the Tex McIver case is being questioned on the record right now without jurors present, because apparently during the break, the witness, the PR consultant, told the prosecutor that he thinks he knows a couple of the jurors. So how this wasn't cleared up before he testified on direct is a bit beyond me. Questions as to who he knows and how he might know them. The version of it that I'm getting from our trial producer, Kathy Russin, is that the witness recognizes faces but not names. And the judge is trying to ask this witness about that. So yet we've got another bump in the road.
Welcome to high-profile
in the Tex
homicide
McIver
trials.
case.
Right.
Yeah.
It happens all the time. There's always some issue that happens in a high-profile case that you wouldn't find in another case.
So that's what's going on right now. We can go back to the Aaron Hernandez case. So we know the unfortunate ending
Right,
to this.
and
know
we're
that
all of us in the defense team are still very traumatized by what happened to Aaron at the very end, because we all got very close to him. We see him and we saw him in a different light than the media persona that has been swirled around Aaron. We knew Aaron as very kind. I sat next to him, as you pointed out, during the whole trial. I was the one who had the most contact with him, probably anybody on the defense team, on a daily basis, and we're also very traumatized that. And I would like to just say one thing, that Aaron Hernandez loved Shayana and his daughter more than anything in the world. That little girl was the star, the light of his life, no matter what happened.
it's sad what happened. Now we know that we've got a civil case looming.
Right.
We've got accusations floating out there that he had CTE damage.
He had them, right, clear.
To, you know, one of the accusations in the civil complaint that Jose Baez's firm is continuing to handle is that he had the brain of a 67-year-old.
Right.
Years of NFL hits, years of playing in the NFL. Was there anything that struck you in your course of knowing him that now perhaps makes sense now that we know a little bit more about the medical diagnosis? Was there any signal that something like this may have been going on underneath the surface?
You know, we weren't focused on it, but looking back, maybe the loss of memory, certainly actions that people would interpret as being not appropriate, but nothing to say that he was a murderer on it. But we probably would have looked back at some losses of memories that he had and an ability to formulate words and all, that now we would say, yeah, we would look back, but we were so focused on the fact that we had an actually innocent person, we didn't. But there was nothing we could do about it anyhow. I mean, he did. The doctor at the CTE Center in Boston said the worst brain he'd ever seen was somebody who had left playing football 24 years old. Remember, he was 27 when he died. Mm-hmm. So it just is a very, very sad state. And it's also, but one thing, we hope something good comes of it, that maybe people take heed, that maybe we have to do some research and prevent young people from getting concussions, because you don't want to have anyone to have brain damage.
Interesting observations, because you know, so many people would want to know, what's the guy like when he's sitting there as a client? And I know that you have a confidentiality with him, but your impression of him was not only direct, but limited, because you're trying to do your job. Right. You're trying to make sure that you take care of this issue that's in front of your client right this instant. And you know, it's not uncommon for clients to sometimes forget something or whatnot, but then looking back hindsight is always a 20/20 situations like this.
Looking back, maybe those were some indications that he had the CTE on it. But you know, we again sitting next to him, people. To me, he was very good. He was attentive. He answered every question that I had. Sometimes, again, he couldn't remember some things, but he answered every question I could have. And you know, there was a point in the trial, I think you remember, that I went to the hospital on an emergency room basis. I had somehow abraded my eye, abraded my cornea in my eye, and I actually came back to the trial wearing a bracelet because I'd forgotten to take it off, and I was wearing sunglasses too, because as you know, you can't get the light in your eye, and something was wrong with it. And Aaron actually took my hand and was like focusing to try to get something out of the eye. So I mean, he was very attentive to his team, and he wasn't the monster that people want to make him out to be. Aaron was very kind to his team, and we felt that the Aaron that we knew was a different person than the Aaron that had been portrayed.
Was he the kind of client that you wish you could have had many times over again?
Yeah, absolutely. You know, Aaron wrote most of us letters that he was looking forward to seeing us, and we were looking forward to representing him. We thought that we had a good possibility of getting the other case reversed based on what we had read.
And of course, we don't know for sure now. We won't know the finality of that. Right. But certainly appreciate your insight into it. It was a case that we kicked off with here at Law&Crime. Back when we were Law News. We've since changed. So your insight is certainly valuable.
Right, great being here.
I want to keep talking, though, as we wait for things to kick off again in the Tex McIver case. Just want to let everybody know we're still in the midst of this issue as to whether or not the last witness knows someone in the jury, and now the judge is questioning some members of the jury individually on this one. So, look, how do we make sense of this mess? I mean, what's the remedy? If it turns out that they vaguely know one another, I mean, look, this guy's a PR person. He's got a column. He's syndicated. He's on the radio. He's on TV. Is it maybe that
it's going to depend on how much he
meets a lot of people? Did he meet somebody at a charity event and just happen to sit next to him and doesn't even remember their name, or what?
It's going to depend. What if the jurors really knew him? What if they're friends with, like, one juror's friends with his wife? It's going to depend about the degree of the relationship, whether any of the jurors lied, if they said they didn't know him, because I assume they were given the witness list. Usually that's what's read to people. But now it'll depend. They'll probably bring, if there is a slight knowing, they'll bring somebody into the judges' chambers. They'll question them. But I don't think they're going to undo this whole trial unless there's a really close relationship between this person and a juror, or a juror lied about knowing him.
It would seem that to be the case. I mean, I sat on a jury once myself years and years ago. Well, you want to know what? It did shape my impressions of things. It was long before I had gone to law school. It was a civil case. It was a slip and fall. And it was against a major store in the area where I lived at the time, and it was a small community, so everybody goes in and out of this store. So, you know, they ask if anybody knows anybody, and it's like, well, we kind of recognize this guy vaguely from work, where he works, where we shop, but we don't know his name. The judge is like, oh, that's fine, whatever. Just you know, as long as you don't have a close relationship with him. And that illustrates the standard.
That's exactly right. But boy, I'm so happy that you appeared. I tried to appear on a jury, and I got all the way to the box, and I found out my husband was a witness in the case. Well,
like, you know, then you wind up with different issues. But, you know, look, I mean, I later clerked in the same courthouse where that case was heard. And it did sort of shape my impression of how things rolled out. I think we might have some testimony resuming now in the Tex McIver case. So let's dip back in if we can. We've got the witness back on the stand. Folks, we are in that point in questioning in the Tex McIver case in Atlanta, Georgia, where members of the jury get to ask their own questions. This is something that we see some judges do. Some states don't allow it at all. Some judges do allow it. Some states do allow it. So we have that process going on right now, and we can take a look in the courtroom and show this to you and explain what's going on. The questions come in on these little cards. The judge looks them over. Then the attorneys look them over, because questions from members of the jury are subject to objections just the same as a question from opposing counsel. So the attorneys on both sides can object to a question from jurors. If there's no objection that sticks, then the question gets asked of the witness. And it would seem to me, Linda Kenney Baden, who remains with us, this is a great chance, as we say frequently, for attorneys to really look in the mind of what jurors are paying attention to. Or
one juror or two jurors, but you always have to remember, because it's just like when you get a question when they're already in deliberation. That may not be the whole jury, but it is interesting. We as lawyers do like it, because you get a hint that at least some juror is interested in something, and you may want to address it later on with testimony, but you can't go crazy over the questions. I mean, even when they come out in a jury verdict, you can't go crazy over the questions, because it may just be one person's perception, and then it goes away.
Maybe all of these are coming from one juror, but they get to look at the handwriting, so I guess that they would be able to tell.
Right.
So here we've got this witness on the stand, and I'm curious to see what jurors ask him, but questions about whether or not Tex McIver was really using this PR person, who was a friend, to spin lies in public aimed, as the prosecutor alleged, at the police and the prosecutor, or is it something less nefarious? Is it that the defendant wanted to protect his wife's friend who was driving the car from an onslaught of publicity?
Sure. I mean, you know, there's already an indication they were really good friends, the wife and the driver of the car. And sure, I mean, if it's not to cover up, why? I mean, what relevance does it matter who was actually driving the car? You could have had, you know, one of the seven dwarfs driving the car. The question is what happened in that car. And everybody knew, the police knew that she was driving the car. So what if the public didn't know she was driving the car? So what?
Yeah, I mean, this is another one of these pieces of this puzzle that seems like it could be characterized a couple of different ways. I mean, it doesn't look good either way, but it looks really, really bad one way, and it looks just questionable another way. I mean, surely this guy should have known better than to try to, you know, do this that way. I mean, he could have said, you know, Danny Joe, you might want to hang low here because there's going to be a lot of attention on this. That's one thing.
Yeah, he could have said to her, look, I'll try to protect you from as much hullabaloo as you can, but you're going to ultimately have to talk to the police. But you know, when your wife dies or any loved one dies, I would argue that sometimes you don't do things reasonably and rationally. So there could be an ulterior motive. But, you know, this testimony to me didn't drive the ball forward as to whether or not he intentionally killed his wife. And that's what you want to do as an attorney.
Yeah, this is about intent. Let's go back. I think they're going to start asking the jury questions any second. Again, the top charge here, murder. They have to prove intent in Georgia. Let's listen in. We're expecting to get the jury questions anytime. We have reached the end of the day, folks, in the Tex McIver case out of Atlanta, Georgia. The murder case involving a former attorney who's accused of intentionally shooting and killing his CEO wife, Diane McIver. This case involves 7 charges. We have murder, we have felony murder, we have aggravated assault with a deadly weapon, we've got firearm possession during a felony, and 3 counts of influencing witnesses. Now, this witness who's been on the stand all afternoon is a PR executive who was helping Tex McIver. issues here as to whether or not Tex McIver was saying things that got reported, and then Tex McIver asking for his PR friend to try to say that he never said those things. So, Linda Kenney Baden.
Yes.
Do we have the defendant really trying to spin the narrative, change the story, clean up some facts that aren't in his favor? All of the above, none of the above?
I don't know. And that's a problem for the prosecution. You have to prove the case beyond a reasonable doubt. And those questions that I just heard from the jurors were very interesting, because they're asking him, well, the defendant specifically authorized what was said? And he said, well, he went and took a sleeping pill and fell asleep, so I couldn't ask him, but he didn't ask me to retract it. So what does that mean in the scheme of things? And where does that get us to whether or not he intended and had a motive to pull the trigger and kill his wife intentionally?
Yeah, look, this case, I said this before, and you told me to repeat it, so I'll tell everybody who's watching. This case is swimming around like the goldfish that I had in elementary school.
Whose names are?
Fins and Goldie.
Right.
You know, when you're in first grade or whenever, when I got fish, you name them as a kid would name fish. But look, I mean, somewhere in this swimming around in circles and flips and loops and whatnot, there's a couple of points, but they can be characterized a couple of ways. And look, it all boils down to whether or not that trigger was pulled intentionally,
right,
and whether the state can prove that beyond a reasonable doubt. The state's trying to get motive in there. You don't need motive in Georgia.
That's right. You don't need motive anywhere for an intentional murder, as long as you show that you intended to kill somebody. The interesting issue is if he was reckless, which is an aggravated assault, and the jury finds he was reckless because he handled the gun not knowing whether it was loaded and hit through a plastic bag, and he kills his wife unintentionally but recklessly, does that constitute a felony murder that they've indicted him for also, or charged him with? And that's an interesting legal question. It would drive defense attorneys crazy if that's how the jury is going around, thinking that he may not have intended to kill her, but he killed her accidentally, recklessly, and therefore find him guilty of felony murder, which will carry the same sentence.
Yeah, that's just very bizarre, because normally, and we've said this before, felony murder is when there's a felony and then someone dies. And the classic example that everybody gets in law school is there's a bank robbery.
Right.
And then someone is killed in the commission of it, while the people who perpetrated the robbery can all be held guilty accountable for the murder,
right,
or the death that occurred as part of the bank robbery. But it's kind of weird to see aggravated assault, which would be the gun going off and the bullet striking Mrs. McIver, being ratcheted up to felony murder just because she didn't survive the attack. That's sort of a convoluted use of the felony murder
right,
rule.
Because then the question really should be, was it manslaughter, involuntary manslaughter? And we're going to find out. You got a long way to go with 5 witnesses for the state.
Well, yeah, and we've got a case that's already gone into 15 days. It was supposed to last a couple of weeks, and the defense doesn't even have the case yet. So we will continue to monitor
it next
here.
week.
Yeah, right. Well, I will be here. I don't think you will be. It's been great to have you.
I'm coming next week.
Oh, are you? Okay, excellent. It'll be good to have you back.
Nice seeing you.
Linda Kenney Baden, the person who needs no introduction, is here on Law and Crime. So, Tex McIver will be back in session tomorrow. We also are continuing to monitor the courtroom in the William Knight case in Ohio. That's the case of a man who's accused of a shooting who turned out to be an unarmed African-American man on a dirt bike. The issue whether or not the law of self-defense applies to protect the shooting. Was the victim circling back around to harm a member of the shooter's family? That's the question that the jury is grappling with. They are in verdict watch right now. We will continue to monitor that situation on our raw feeds. You can always go to lawandcrime.com, click on the live tab, and see the feeds that come in to us. But for now, here on the network, we're going to sign off with my reminder that we're on the air from at least 9 a.m. until at least 5 p.m. Monday through Friday with live coverage of trials and hearings around the country. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a good evening.